Good morning. Welcome to this morning's session of the Kansas Court of Appeals, meeting remotely by Zoom. We appreciate your willingness to join us in this way and your flexibility this morning, Council. My name is Catherine Gardner, and I will serve as the presiding judge, which mostly means that I'll be keeping time for you today. With me today is Judge Kim Schroeder and Judge Amy Klein. And I believe all our cases this morning, the first two are 15 minutes and the last one is a 20-minute case, but we'll go ahead and get started. First case is the case of Jerry Shelton, trustee of the Jerry Shelton Revocable Living Trust, as appellant versus David M. Chacko and others as the appellees, number 123092. May I have your appearances, please?
Your Honor, may it please the court, John D. Beverlin II, Stoll, Beverlin, Nicolay, and Haas, on behalf of the plaintiff, cross-claim defendant, and appellant, Jerry Shelton, trustee of the Jerry Shelton Revocable Living Trust.
Good morning. May it please the court. Defendant appellee David Chacko appears through counsel Hannah Brass.
Sorry for the interruption. This is Kathleen. I believe we've lost Judge Gardner.
We have.
We can wait a moment to see if she will log in again.
Technology can always be interesting.
There we go. Okay,
Yes.
I am back. Thank you. I apologize. Not sure what went on there, but let's start again with appearances, please, for the case of 123092.
Your Honor, may it please the court, John D. Beverlin II, Stoll, Beverlin, Nicolay, and Haas, on behalf of the plaintiff, cross-claim defendant, and appellant, Jerry Shelton, trustee of the Jerry Shelton Revocable Living Trust.
Thank you, counsel.
Good morning, Your Honor. May it please the court. Defendant appellee David M. Chacko appears through counsel Hannah Brass.
Very good. Mr. Beverlin, you may begin.
Your Honor, this appeal involves a disputed tract of land in Barber County located between a fence and a legal boundary line that runs kind of north to south, approximately 2 miles in length.
And let me interrupt and ask if you'd like any rebuttal time.
Your Honor, I would 3 minutes, please.
Thank you. Go ahead.
The total acreage on the disputed tract is approximately 40 acres. This case was filed as a quiet title action by Mr. Shelton, and Mr. Chacko cross-claimed and asked the court to find that he had adversely possessed that property. The tract runs through section 6, 30, and 32. The court ultimately decided that Mr. Chacko had adversely possessed the tract as to the area that ran through sections 30 and 32, but had not as far as section 6.
And 6 is not on appeal, correct? That's not an issue.
You're correct, Your Honor. Section 6 is not on appeal. The property the area is known after the original founder and a gentleman by the name of Gentry. It's known as the Gentry Ranch. The final heirs to that Gentry Ranch sold that property in 2010. And that property then in 2010 was purchased by, just to summarize, Mr. Chacko, really. It was purchased by an LLC he was a member of, and that's when he began to own that property. One of the issues that the appellant raised in its brief was whether Mr. Chacko himself had met the burden to show the court that he had adversely possessed that property on the belief of ownership. Today, I'm going to concentrate my argument really on his predecessors in interest. Because he acquired that property in 2010, Mr. Chacko must rely on tacking in order to show that he has met the requisite 15 years under 6503.
Mr. Beverlin, Would
Yes,
you
sir.
agree that the 15 years we're looking at is the 15 years immediately before he filed suit, or that Shelton filed suit?
Correct.
Okay.
And really, my concentration is between the period of 1974 and 2010. And ultimately, the appellee has taken the position that that statute of limitations period, that 15-year period, ran starting with construction of a fence between what we've termed the Chacko property and the Shelton property. It's the appellant's position that 15 years would not have commenced until he divested or sold that property in 2010. And the reason, the basis of appellant's argument is in the Dotson case. And, to break it down into eras, okay, and without getting into the weeds about all the facts in the case, Mr. Klein.
Let me just ask you a question. If the Dotson case does not apply, what is your position?
If the Dotson case does not apply, then our position is that Mr. Chacko himself did not show the requisite intent based on conversations he'd had about moving that fence in after the 2016 fire.
But the district court made a finding that that wasn't credible evidence, and Mr. Chacko's testimony that he did not do that. We're bound by it, aren't we?
Well, you're right. Standard of review would be whether the district court's finding was based on substantial competent evidence.
Do you have any Kansas adverse possession cases that have applied or relied on Dotson?
None that I could find that relied on Dotson.
Seems like maybe that principle functions when adverse possession does not, that they don't work together. It's one or the other.
Well, I guess I would disagree. I mean, the basis of our position is that the grantor-grantee relationship, as Dotson highlighted or seemed to base its decision on, is applicable here. And the reason is, while the district court took the position that Mr. Klein did not possess, legally did not own the Chacko property because he just had a vested remainder, our position is that he did possess the property. He had made clear in some reservations in a deed that he was involved in the Gentry Ranch. This area was known as the Gentry Ranch. Mr. Miller had testified that years of farming by Mr. Klein had built a ridge to the west of that boundary fence that because of blowing, the way he farmed, it caused blowing that built up that ridge. So clearly, even as a 3/10, finally inherited 3/10 interest and became the majority owner of that property, but he was well active in managing the Gentry Ranch, but before he became owner. So he possessed the disputed tract after he sold that property to DNB Drilling, was the original grantee.
But doesn't that all go to whether you could possess adversely to yourself? And you're saying, no, you can't do that. And here, we're not going on that adverse possession prong under the statute. The claim here is only under a good faith belief of ownership, is it not?
It is, but that's ultimately what the court decided. And that's what Appley's position is. And that's obviously the easiest position. But again, in that Dotson case, the grantee had to be made aware of the grantor's intention in retaining that property. And there's no evidence that any DNB Drilling knew why Mr. Klein was retaining that property or possessing that property. And so because there was no, and I think the court called it a clear, just to use the correct term, like clear, positive, and continuous disclaimer of that title to that property. And there's no evidence that Mr. Klein ever and I'm going to use the broad time period between 1981 and 2010, that there was ever a clear, positive, and continuous disclaimer or disavowal of the title to that property.
Is that the language by the court that makes you think it applied the Dotson principle, or that it had Dotson in mind in some way? Because it never cited that case, I don't believe.
You're right. The court relied on some secondary sources, and the district court said that in part of its decision basically said that if you retain a small portion of property you granted under a belief of ownership, then you can adversely possess that property. But for appellant, we believe that that's only applicable when you're retaining it because you own the property next door, that you're retaining a part of the property owning. He didn't possess the disputed tract as part of ownership of a larger tract because he didn't own that property at the time. He owned that property later on, but he did not own that property at the time the fence was built.
Was there any testimony in this case by Wesley Klein or any of his 11 co-owners after their predecessor died?
Mr. Klein was 67 when his mother died in 94 and died later on. I mean,
So there's no testimony by any of those co-owners from if I'm looking at 2003 to 2010 to get 7 years to add to the 8 years that Chacko owned it from 2010 to 2018 to get the 15 years that I'm looking at to tack on. Is there any testimony as to what those owners prior to Chacko believed about where the correct property line was?
There was no testimony, and again, that kind of gets to appellant's second portion of the brief was that there was not clear and convincing evidence that was presented sufficient to show that those predecessors in interest in Mr. Chacko had a belief of ownership.
Well, doesn't the placement of the fence establish some level of ownership belief when you control on the left side and the Shelton owns on the right side, or vice versa?
Except that the Dotson case the Dotson case, the railroad had a spur line. I mean, that's clearly use of the property similar to building a fence and using it as farmland as what the property out there is intended for, has been forever used. So Klein conveyed the land to DNB Drilling in 1991, if I remember correctly. In 1981.
81. All right. Then Klein didn't get a hold of didn't have a vested interest in the Chacko property until 1994.
Correct.
But between 1981 and 2018, no one made an issue over the placement of that fence out there.
Not to my knowledge. There's no evidence.
There's no record that shows that.
There were some surveys done and some comments between landowners, but correct. There was, other than that, no.
So what did happen in 2016 after the fire? I mean, apparently Mr. Chacko was addressed by his ranch manager who said there's something, I mean, he had some concerns that the fence was not on the boundary line. Tell us the details of the facts of record relating to that.
Your Honor, there's some hearsay, which I attempted to keep out of my appellant brief or rely on it, but essentially,
the evidence that was admitted, if the evidence was admitted, that's what
essentially, essentially it was two ranch managers, Mr. Ricky, and then, and I forget
Kennedy?
the second one, but
Rimmel?
Kennedy?
Or Rimmel.
Oh, Remmer, I'm sorry, Kenneth Remmer and Mr. Ricky, and Mr. Ricky was under the impression that the landowners had agreed that they were going to move the fence back to a fence line. At that point, a survey had been done in 2015, which confirmed a previous partial survey done in 2012 that the fence line on sections 30 and 32 were not in the correct spot. The fire presented an opportunity then for moving of that line, and Mr. Ricky, who is also Mr. Shelton's ranch manager, had done what was necessary, thought there was cooperation on the other side, showed up with staff or employees or somebody who was going to build the fence, had the land surveyed and was going to put the fence on the other side. And apparently there was a crunch of time because there were cattle and the cattle needed to be contained. And so the fence was ultimately put back using some of the same posts that had been in existence before the fire.
And it was put back by Shelton staff?
It was rebuilt by Mr. Chacko's staff.
Okay.
Yes. He experienced some kind of either he was getting cattle delivered onto the property or he already had cattle there at the time of the fire and was concerned about containing that cattle.
You have about 2 minutes before your rebuttal time.
Your Honor, I think I got everything that I want. I guess it is appellant's position that that the intent of the grantee or grantor in retaining that property must be communicated. The Dotson case provides that if the relationship between the party was such that the grantee and grantor were strangers, it's our reading of that case that for example, if Mr. Klein had entered the property, taken the property when there was a subsequent grantee, so when Mr. Miller owned the property, then we would be in a position entirely different. There would not be the same kind of relationship established and provided for in the Dotson case. And therefore, then the adverse possession could start at the time the fence was constructed. In this case, though, the evidence is clear that the fence was constructed before Mr. Miller purchased the property, that it was probably constructed between that 1974 to 1991 timeframe. And therefore, the Dotson holding then extends to subsequent grantees. It's appellant's position then that the 15-year statute of limitations as established in 6503 could not begin to run until 2010 when Mr. Klein sold the property to Mr. Chacko's predecessor in interest.
All right. Just correct me if doesn't Miller sold to Shelton?
Miller sold in pieces. He broke up the ranch, sold it to essentially the Kovaches and then to Riceland.
Right, but the chain, the Shelton's chain comes through Miller.
Shelton's chain
Chain of ownership
comes through the Riceland group, the Riceland Properties, Kansas.
But Miller sold it to Riceland.
But Miller sold it to eventually Riceland put it all together.
Miller, if my memory is correct, Miller testified that he thought the property line was the fence.
Miller testified that he thought the property line was the fence.
And Miller had possession of the land from 1981
till he sold it in pieces starting, I think, in 1991 to 2012.
1991 until he started selling it out and ultimately Shelton obtained possession.
Correct.
Ownership. All right. Thank you.
Thank you, counsel. Ms. Brass?
Thank you, Your Honor. We do believe that there was sufficient competent evidence in the findings made by the court to support the district court's holding. In the interest of time, I'll not rehash the entire brief, but I do want to discuss the Dotson case somewhat. We've had quite a bit of discussion about that today. Both briefs cite to the Dotson case at length. We believe that the Dotson facts are distinguishable from the present case. The holding in that case states that when a grantor continues to possess land after granting it to a grantee, that possession is not considered to be adverse to the grantee until the grantor explicitly renounces title and until the hostile claim of title is brought to the attention of the grantee. Appellant has argued that the district court expanded that Dotson presumption by concluding that a grantor can later adversely possess the tract in situations where the grantor retains the property under a mistaken belief that the grantor owned the property. We don't believe that that was the case here. This case is distinguished from Dotson. Wesley Klein was not a grantor who continued to possess some portion of the land subservient to his grantee. Wes Klein deeded the land to his grantee, D&B Drilling, and then his mother continued to possess some portion of the land, the disputed tract, which she had already possessed for an unknown number of years. I think it's also important to consider that the Dotson case was decided in 1910, prior to the adverse possession statute being amended to include a basis for a good faith belief in ownership as grounds for adverse possession.
Well, the Dotson case was not an adverse possession case, correct?
That is correct, Judge.
Did you argue the Dotson case to the district court?
No, Your Honor.
Neither party did?
No, Your Honor.
So you seem to be assuming the Dotson case would apply here in this adverse possession case, but it's factually distinguishable. And our question is, do we even look at Dotson in an adverse possession case? Could you address that?
Sure. Our position is that no, you don't need to address it in the adverse possession case. I think the Dotson case focuses pretty heavily on privity of contract and the negotiations between the parties and what was represented to those parties in a particular transaction. And I don't think that while it may be informative in some adverse possession cases, I don't believe that it should become a cornerstone of adverse possession law because it is too distinguishable, Your Honor.
Thank you.
Mm-hmm. I do want to go back to the Dotson case for just a moment here to talk about the.
Tell me, if Dotson wasn't argued by or to the district court, why does it even apply in this situation? Because the district court never had a chance to address its application.
That's correct, Your Honor. And I was rebutting the Dotson case because that was relied on pretty heavily by appellant in its brief as a basis for why, essentially establishing that there was concurrent ownership of the Chacko and Shelton properties by Wesley Klein, making him a holdover grantor, unable to adversely possess the disputed tract. We don't believe that the Dotson case applies to the facts before the court today.
Thank you.
As the court has already noted, Wesley Klein did not have a concurrent ownership of both of those properties. He was only a vested remainder on the Chacko property at the time that the fence would have been constructed. And he can't adversely possess against himself, as we've noted, or as both parties have noted. He did own, of course, the Chacko property and the Shelton property, but not at the same time. The only time of concurrent ownership, true concurrent ownership of those properties dates back to J.H. Gentry and ended with him upon his death in 1933. There's no overlapping period of ownership and therefore no logical basis where the court could find that there was a party who adversely possessed against himself. And I also want to address the claims raised by appellant that Mr. Klein's use of the Chacko property during his mother's lifetime does give rise to a possession that would defeat some kind of adverse possession claim. I don't believe that's well supported by the record. There was testimony that he helped his mother out in farming. There was no evidence in the record that he had a legal right as a tenant, that he was there operating it daily. There was also quite a bit of mention in the appellant's brief and then some in the argument today about the easement in Wesley Klein's deed to D&B Drilling, retaining a right of access to certain sections. And I think it's important to note that easement specifically refers to access of sections 6 and 7 to benefit those properties. The disputed tracts are not in 6 and 7. The issues before appeal today are in sections 30 and 32. So I don't believe that that's basis. They also relied quite a bit on Mr. Miller's testimony that Wes Klein's farming practices created a ridge because of the blow sand. There was no testimony about when that occurred. There's no evidence in the record about when that happened. For all we know, it could have happened sometime after 1994 when Wes Klein was a fee simple owner of the Chacko property. The fact that there was a ridge there because of Wes Klein's farming practices is not conclusive evidence that it was because of his farming practices prior to 1994. Moving on to the second issue on appeal about the good faith belief in
Well, let me,
ownership.
I guess, what does the ridge have to do with the fence?
Your Honor, I believe that appellant's argument is that there was a ridge right along the fence, and the ridge was caused by Wes Klein's farming activities on the Chacko side of the fence. And they're trying to use that as evidence to show that Wes Klein had some kind of possessory right or present right to use on the Chacko side of the fence sometime prior to 1994, sometime prior to becoming a fee simple owner.
So the Chacko property has the ridge on its side of the fence.
My understanding from Mr. Miller's testimony was that the ridge is essentially at the fence line, that it was farmed up to the fence, and the field, the cultivated side, was lower because the sand blew out over time.
And that would be Chacko's side of the fence where they farm.
Correct. Yes, Your Honor.
All right.
As you address, oh, go ahead, Judge Schroeder.
Well, so the farming up to the fence shows that Klein maintained possession of the land up until the time that he sold it to Chacko.
That's correct. And there was testimony that some of that was planted back to grass later, but I think the important fact for our argument here is that there was no evidence about when those farming practices began, and we can't rely on the fact that this ridge existed to show that Wesley Klein had a possessory right to the Chacko Ranch before his mother died in 1994.
Well, let me add, I think for the 15-year period under the statute that we're looking at has nothing to do with that early in time. The 15 years is the 15 years before Sheldon brought suit. So we're looking at 2018 back to 2003. So from 2010 to 2018, we've got Chacko in possession and his good faith belief. Tacking is okay. And who had the land before that 2010? That was apparently Wes Klein and his co-owners. So speak please to what their good faith belief was during those 15 years.
Of course. As Mr. Beverlin stated, Wesley Klein was deceased, and there was no testimony from any of his other co-heirs or the remaining living co-heirs at trial. So the only evidence from which we might be able to glean Wesley Klein or Beulah Klein, well, relating to your the period of time requested by you, Judge Gardner, related to Wesley Klein, may be found in the testimony of Mr. Miller, who owned the Shelton property beginning in 1991 until he began divesting that property in 2001 up through 2007. He testified confidently that he believed the fence was the property line and that during his time.
But Mr. Miller didn't own the Chacko property. He is the Shelton property. That's irrelevant for purposes of establishing the tacking on to the Chacko property.
And I understand that. Mr. Miller further testified that all parties operated as if the fence line was the boundary line. And the district court relied on that in finding that there was no evidence that any owner believed the property line to be somewhere other than the fence line. Because
how does that not shift the burden of proof? It's like the district court almost found a negative. Nobody showed that it wasn't the property line. When under the statute, it's the adverse possessor's burden to show they did have a good faith belief in ownership.
Yes, Your Honor. And we would refer back to the Buchanan case cited in our brief, that the court stated in that case that when an owner fails to defend his title to protect his rights of ownership, he is deemed to have acquiesced in the location of the boundary or in that hostile takeover. We believe that applies here. We do have limited history to work from because so many of the parties are deceased, but based on all of the owner's acquiescence to that fence as the boundary line between the properties, we think that does provide a basis for the court to find that there was a good faith belief of ownership on the Chacko side of the property for the last 15 years.
But was the Buchanan case argued on, was it a good faith belief of ownership case, or was it in fact under the previous version of the statute or the alternative version of the statute? When you're talking about a hostile takeover, is
Judge, that
I'm
case
asking.
was decided in 1999 after the statute was amended.
But which theory?
Your Honor,
Which
I'm not
theory of the
confident which
Okay,
theory
I
the
can-
parties in
we can
those
check
cases
that out
were
later.
proceeding under.
Thank you.
Mhm. Oh, actually, Your Honor, it was the good faith belief in ownership. The court in that case actually went into quite a lengthy discussion about whether or not evidence in the title record in the Register of Deeds is enough to defeat good faith belief in ownership. They found that that could not be the case. Otherwise, it would lead to illogical results in application of the good faith belief portion of the statute.
Thank you.
I'll wrap it up here quickly. We do believe that the district court's decisions were supported by substantial competent evidence in the record. Although Mr. Chacko did not own the Chacko property for a long enough period to satisfy the 15-year requirement on his own, his predecessors in interest did possess the disputed tract for a long enough period of time and under the standards required by 6503, the adverse possession statute, and that they possessed it openly, exclusively, and continuously for a period of at least 15 years, and that their belief in ownership was reasonable under the circumstances. As we've stated.
I do have one question before you
Yes.
conclude. Why isn't Mr. Chacko's good faith ownership or belief in ownership defeated by his knowledge in 2016 that the survey showed a problem with where the fence was, or the partial survey in 2012?
Your Honor, there is case, and we cited in our brief, I'm blanking on the citation right now, that an owner's later being informed of a defect in the title is not sufficient to impeach his good faith belief in ownership as long as it was reasonable under the circumstances to begin with.
Thank you.
We also believe that, as we've stated, Mr. Klein's previous ownership of the Shelton property is not sufficient to defeat his later adverse possession of the disputed tract, which begins the tacking period for Mr. Chacko's claim. Mr. Klein fully divested himself of the Shelton property. There's also no facts to support a finding that the fence was constructed during a time when one person owned both sides of the fence. The suggestion that a party was adversely claiming against themselves is not supported by the facts here, and that's not the basis of our arguments in this case. We believe there was sufficient evidence in the record to support the district court's finding that Chacko or his predecessors in interest were in open, exclusive, and continuous possession of the disputed tract for more than 15 years under a good faith belief of ownership that was reasonable under the circumstances. Thank you for your time today, and we would ask that this panel uphold the district court's decision.
Thank you, counsel. Mr. Beverlin, you have 3 minutes. Mr. Beverlin, I believe you're muted.
Your Honor, it was previously asked regarding the case law that was argued before the district court. And I do want to point out that in its reply, findings of fact and conclusions of law, the appellant did argue at volume 2, page 309, that Mr. Klein's subsequent ownership of the property and possession of that property did defeat adverse possession. And that was at page 309. I guess I don't have anything further to add, Your Honor, that we did not already further argue initially.
Okay.
Other than to bring that knowledge to the court.
Any questions by the panel?
No.
Okay. Case has been submitted then, counsel. We thank you for your arguments, and we will get you an opinion when we can.